All right, so I'm recording the classes, so I know that there's a bit of a disadvantage to doing things remote as opposed to being in the classroom. So my plan is to record the classes and then post them out onto Moodle so that you can review them should you need to. Depending on how bad COVID is this year and how many people are going to be in quarantine and missing class, I may just decide to record the entire semester. I don't know at this point, but there is a chance that that could happen. All right, so that's the housekeeping as to where we are. Let's talk about. Cannot minimize while I'm recording. Okay. But I can put stuff up over the top. Let's take attendance, see who's here and who's not. Nevaeh Arnold. Nevaeh? All right. Sydney Babel.
Here.
Hey, Sydney, welcome. Matt Castles.
Here.
Okay, great. Grace Sicky.
Here.
Okay. Madeline De Palma.
Here.
Okay. Josh Grigoletti.
Here.
Jeremy Groves. Jeremy. Okay, I know.
Here.
Oh,
Sorry.
good. Travis Harvey.
Here.
Okay, Sydney Hips.
Here.
Seon Huang.
Here.
Okay. Kayla Jewell.
Here.
Okay. Christian Kemp.
Here.
Okay. Yuta Koike.
Yes, here.
Okay. Destiny Merriweather.
Here.
Okay. Jeremy Meyer. Okay, I know where Jeremy is. Brock Newsom.
Here.
Okay. Anthony Phillips.
Here.
Okay. Haley Phillips.
Here.
Daniel Sinisi. Okay. And you're here. Jacob Smelser.
Here.
Walter Tolliver. Walter. Okay. Hallie Vogt.
Here.
Okay. May Williams here.
Here.
Ashley Wolford.
Here.
Okay. And Natalie Zgurich.
Here.
Did I say that anywhere near right?
Yeah, it's Zagorich.
Okay, great. Thank you. All right. So we begin the semester. Sometimes I go back through and do a little bit of review of what we had last semester. I don't see a real need to do that. As you guys that were in the first semester of this course, you know, we really concentrated quite a bit on contract law and such. This semester is going to be completely different. Although contract law is, remember, it's at the base of everything, every transaction that occurs in the business world. We're not going to be studying the contracts. We're going to be studying the laws of different types of transactions in different areas of the law. So should be a little bit more exciting. It's not all contract law. So it's going to be a more of a variety of things that we're going to be looking at. Keeping in mind all of the structure, everything that we talked about, the structure of the governments and who is superior to who, that all stays in place. The federal government is superior to the state government, which is superior to the local governments. The supremacy clause in the Constitution tells us that anything that comes from the federal government at any level is superior to anything below that. So remembering that, for example, federal regulations that are passed by or promulgated by federal agencies are superior to state laws or even state constitutions. So keep that in mind as we move forward, because we have some areas where the federal government does want to interact, and we have other areas where the federal government does not want to interact. If the federal government is in the arena, then they are going to be the ones who make the rules. Okay, so just keeping that in mind. All right, so let's take a look at the syllabus real quick. And I should be able to share this so we can just go over it together. Let's try. Share screen, that would be the syllabus there, share. All right, I'm assuming you have the ability to see the syllabus now. My office hasn't changed. I'm still in AC 30. I hope to be there within the next week or so. My teal phone will be probably relatively useless because I'm not there. Easiest way to get a hold of me is going to be by email. I will be available to you by email. If you have any kind of an issue or any kind of a question, please just send me an email and I will get back to you in relatively short order. The text that we're using is the same text that we used last semester, Anderson's Business Law and the Legal Environment, the 23rd edition. And what are we going to do this semester? Well, this course content will explore the legal issues as they relate to business, including the nature and ethical foundations of law, negotiable instruments, debtor-creditor law, agency and employment, business organizations, and real property. Now, there's also some other stuff in there, course goals to obtain a working familiarity with the concepts of foundation of law, negotiable instruments, debtor-creditor law, agency and employment, business organizations, business ethics, real property, and then also decedents, estates, and trusts. That'll be the very last chapter that we cover is decedents, estates, and trusts. The outcomes, we're not trying to turn you into lawyers. We're not in law school. This isn't even the pre-law stuff that the college has if you want to become a lawyer. But basically, it's an introduction to the law that controls business activities in the country. Not hoping to turn you into lawyers, but basically give you enough knowledge so that you will be able to identify areas of law where we are when you're in your professional world, and understand when you're in trouble. That's a very big thing to learn. As I say in here, you'll be equipped with the necessary knowledge to know when it's time to call an attorney to protect the interests of your business. Okay. And once again, I just go through and recite what it is we'll be looking at this semester, starting today with negotiable instruments. How are we going to go through the semester? It's going to be, the classes will be very similar to how they were last semester. I will be, I don't like talking about it as being a lecture, but especially online, it ends up being a lecture. All I do is talk. When we get back in the classroom, it'll be more of a seminar environment, hopefully with you guys really participating and adding into the conversation. But realistically, what we're going to be doing is having, let's see, there'll be 4 interim tests and a final exam for the course. In addition, the students will be expected to prepare 4 case studies. Each interim test will be worth 100 points. The final will be worth 100 points. Thus, a total of 500 points from exams. And there will be case studies, 4 of them, each worth 25 points, which will be another 100 points for the semester. So your work will be worth 600 points. And I always do have some points out there to help you if you need some extra points. 50 points for participation and attendance. I don't want it to be an attendance thing. I really want it to be a participation thing. So make sure that you are in class and able to participate. Thus, the total will be 650 points for the semester. I will be assigning the case studies. What that means is you will be reading actual decisions by some appellate court somewhere in the United States. I have lists of cases that I will give you. I'm not going to ask you to find cases. So whenever each one of these 4 assignments, I'll give you 8 or so cases to choose from. I know most students are just going to click through and look to see how many pages each one is and choose the shortest one. I tried to choose cases that were not extremely long. I want to say most of them are somewhere between 8 and 10, maybe 8 and 12 pages long, which is not very long for a legal opinion. I will require that each of these assignments for these case studies be given back to me in a very specific format. We will go over that format in detail prior to the first assignment. But the reality of it is I can tell you it's what I refer to as IFRAC, IFRAC, and it stands for issue, rule, issue, IFRAC, issue. I'll have to actually pick that up. Rule analysis. Oh, issue, facts, rule analysis, analysis, and conclusion. So basically, there's your outline for how the paper is to go. Read the case. Tell me what the issue in the case was. Give me some facts to so I can understand what's going on in the case. Rule. What is the rule of law that is being questioned? A is analysis. Tell me about the analysis that the court took to apply the facts to the rule. And then conclusion, how did the court rule? And then I'd also like to know what your opinion is, because you may or may not agree with what the court says. So those will be some interesting times. So it's 4 homework assignments during the year. You need to read something and then give me a paper back. Once again, I'm not looking for multiple pages on the assignment. A page or 2 should hopefully be enough. I'm not looking to read through 5, 6, 8 page homework, so a page or 2 will probably be fine. Attendance and participation, we can talk about that if you like, but please just come to class. It makes it easiest. You'll learn more if you actually are listening to the lecture. And I'm required to take attendance, and keep in mind that the school will take action against you if they feel that you're not attending class properly. So just come to class. You're paying to be here. You may as well come. Makeup tests. I do believe in makeup tests. If you guys have to miss an exam for some reason, I understand that life is out there and it can easily get in the way. So let me know you're going to miss the exam, and we'll make arrangements for you to have a chance to make it up in some manner or another. Please just not show up for the exam. Let me know you're not going to be there. Homework should be submitted to me by the date and time that I give you. I will post all of these on Moodle like I've always done. There'll be a Dropbox on Moodle for you to submit your homework assignments, those 4 case studies. There will be a due date and time. Please get them turned in on time. I will probably accept them late, but if they're late, I will deduct a portion of the grade. What else do we have here? Please to participate in discussions because it makes the class more fun. It'll go quicker, blah, 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 all that good stuff. There's how you, once again, the grades or the points that are available for the semester. There's the breakdown as to how the semester, if you want to look at your grades. Right here in bold print, it said, this is the method in which your grade will be calculated. Please only use Moodle to keep track of your grades and attendance. Moodle will calculate out a grade for you, but Moodle doesn't always calculate the same way that I do. And you can end up with a rude awakening if you are relying on Moodle to calculate your grade for you. If you have any question, come to me and we can certainly look at it. But, if you just look at what's available out here for grades, if we've had 3 tests, that's 300 points that were available, and we had 2 of the homework, so it's another 50 points. So if there are 350 points available and you have 250 points, you can calculate your grade by dividing 250 by 350 and coming up with what your current status would be. Please, later on in the semester, don't talk to me about, well, Moodle said this and Moodle said that. I don't use Moodle to calculate the grades. You shouldn't use Moodle to calculate the grades. I'll tell you that the big thing there is that if it's going to be mostly the homework assignments. If you don't submit a homework assignment and I grade everybody else's and I don't give you a 0, then Moodle doesn't use that as a part of the calculation. A lot of times I won't put the 0 in if you haven't submitted it, hoping that you will submit it and I'll have a chance to give you a grade. Maybe what I should do is I should just put the 0s in if you don't submit the homework, and then Moodle will be correct. So maybe that's what I'll start doing. I don't know. Accessibility, this is required to be in the syllabus. Anybody that has any kind of a recognized disability or needs any kind of assistance with accommodations to help them be successful at Teal College. We support you, and we support any need that you might have, but you have to go through the proper procedures in order to get those accommodations. We do have the what is it called? The Accessibility Resource Center, the ARC. It's over in the TLC. And you need to talk to a person by the name of Erin Bain. She is in charge of all of that. So please, if you have need for any kind of special circumstances, talk to Erin over at the ARC, and they'll start the ball rolling to give you whatever assistance that you might need. Attendance policy. You can look through here if you like. Last semester, they started doing this. Many of you may have received emails from Greg Butcher, the Associate Dean, explaining to you that there are a number of absences that they've noted, and that if you don't start going to class, that you can be administratively removed from the class by the college. And if your attendance is bad enough that they can remove you from the college, one easy way to fix this problem, just come to class. Academic honor code. Basically, it says, please don't cheat, because if you cheat, then I've got to do stuff about it. I'd rather not do stuff about it. I'd rather everybody just come to class, take notes, ask questions, and you will receive great grades, because I've designed the course to be doable. The key to passing and doing well in a class that I've designed is basically to come to class, listen to the lecture, take the notes, do the homework, do the assignments. For God's sake, do the assignments. And then you'll also do well on the tests. It just automatically happens if you do all of those things. You're not supposed to have the right to record class content. I do have the right to record class content. And at this point, I am planning on recording, at least while I'm remote. I will record all of these classes. I don't know what I'm going to do once we're back in the classroom. I may decide to record, I may not. I'm not sure at this point. COVID response. We don't know what in the world's going on, do we? Who expected that we would be in the middle of another massive outbreak that's actually worse than the first time through when COVID first started? School is open. Most of the world is open. It's not going to be closed. Politically, it's not expedient to close down the world again. So I don't think we'll ever see that happen. But what it does is it puts us all at risk. The school has a COVID policy as far as how you can associate and what you can do, and a masking policy and those things. Please follow those rules. It'll keep you safe. It'll keep your fellow students safe. It'll keep me safe. I want to be safe too. I may have to change how we deliver the course. So for example, although I was planning on being remote today, everybody is remote today. And that's a combination of the weather and COVID that caused that to happen. Just understand that we may end up needing to be flexible as to how we do things as we go through the semester. If I end up being remote, either because of COVID or any other reason, you will receive emails from me. So make sure that you watch your emails. Obviously, there's a bunch of you online with me today. So my email system worked for at least this class. Cell phones, we're not in the classroom right now, so I don't really care what you do with your cell phones. Once we get back into the classroom, I'd prefer that you not have your cell phones out. I'd like to have you have them either turned off or at least on vibrate. The one thing that I've told all my classes, and I told most of you last semester, is you're supposed to be juniors and seniors in my class. Juniors and seniors are looking to get jobs. And I don't want to be the person that costs you a job because you had to have your phone turned off during my class and you didn't get that call, which was an offer for a job. I want you to take that call. If you're in my class and you're waiting for a call like that, you better have your cell phone on. Just have it on vibrate. And if that call comes in, excuse yourself from the class, go in the hall and accept that job offer. That's what I want for each and every one of you. Just don't be disruptive to the class. Excuse yourself into the hall and take your call. I have no problem with that. Teaching approach, supposed to be a seminar. Like I said, right now during remote, it's going to be almost lecture, all lecture. You guys can chirp in anytime you want. I do like having not cooperation, but participation from the class. I do like cooperation too, but participation from the class. Please feel free to add your comments in anytime you like. I welcome them. You know that I'm not the greatest person about getting things graded immediately. That's my weakness, and I work on it every semester. So I will do my best to get things graded as quickly as I can. Once I give you a grade, you have 7 days to argue with me about it if you think that there's something wrong with it. Here's what I think we're going to try and do for the semester. I had to adjust this at the last minute because it was originally put together for us starting last Thursday. But here's what the semester is going to look like. Chapter 27, we're going to start today, which is negotiable instruments. Chapter 28 is transfers of negotiable instruments. Chapter 29 is liability under negotiable instruments. And chapter 30 is checks and fund transfers. So basically, this first grouping of material is going to be about the financial industry, banks, and the movement of money, if you will. We'll have an exam, I anticipate, around February 1st on these first chapters 27 through 30. Then beginning February 3rd, we'll start with chapter 31, debtor-creditor relationships. Chapter 32, consumer protection. Chapter 33, secured transactions and personal property. Chapter 34, bankruptcy. And chapter 35, insurance. February 8th, in the middle of that grouping of material, we will have the first case study due. We will talk about that more in depth probably a week or so from now. February 22nd, I expect the second exam to be scheduled. February 24th, starting with chapter 36, agency relationships. Chapter 37, third parties in agency. Chapter 38, regulation of employment. Chapter 39, equal employment opportunity. So this is going to be all about third parties, agencies, and employment. Second case study will be due February 24th. March 15th will be exam number 3. Unfortunately, the way this material falls is we will finish the material right before spring break, and we will have the exam right after spring break. So in order to fit everything in, that's the way it's going to fall. So make sure you take, when you head off to Florida for spring break, just make sure you take your B-Law book with you. March 17th, we'll start with chapter 40, types of business organizations. Chapter 41 is partnerships. 42 is limited partnerships, limited liability companies, and limited liability partnerships. Chapter 43 is corporate formation. 44 is shareholders and corporations. 45 is securities regulations. 47 is management of corporations. 46 is accountant liability and malpractice. A lot of you are studying to be accountants, so that will be a chapter that you'll enjoy, or at least you should pay attention to. March 29th, we'll have the third case study due. April 12th will be exam number 4. And we run right to the end of April with classes. So starting April 14th, chapter 48, real property. Chapter 49, environmental law and land use. Chapter 50 is leases. And chapter 51, the last chapter in the book, decedents, estates, and trusts. On April 24th, which is the second to last class, is when the final case study number 4 will be due. And then according to, I believe I have the right finals schedule, our final in this class would be Friday, May 6th. at 8 o'clock, and that of course will be in our classroom. Strangely enough, I always teach this class in AC 40, but we are scheduled this semester to be in AC 33, I believe. So the final exam will be in the classroom that we are normally in. Any questions about the syllabus? All right, I'm going to stop my share then, so I can get my screen back. All right, no questions? Okay. Let's start the material then. So we've wasted a half hour of the first class. Let's see, I'm going to get my book here. And I am going to get my study guide out. Just going to take me a second here. All right, so as you guys know, I give you a study guide for every chapter. So chapter 27 is basically negotiable instruments. So the title at the top is kind of instruments, parties, and negotiability. So we're going to start with the fact that we're going to be talking about commercial paper. Commercial paper, that's a term that we need to be aware of. Commercial paper definition, according to the textbook, is a written, transferable, signed promise or order to pay a specified sum of money, a negotiable instrument. Okay, so according to your book, commercial paper and negotiable instruments are the same thing. Okay, and if you look at that definition, written, transferable, signed, promise or order to pay a specified sum of money. Now, whenever you see a list like that in my class, those are the elements that are required for, for whatever it is we're talking about. But in this instance, it is, got a message coming here. What is it? All right. So anyhow, those are the elements of commercial paper. And let me roll down further here. Let's look at the definition of a negotiable instrument. Negotiable instruments: drafts, promissory notes, checks, and certificates of deposit that in proper form give special rights as negotiable commercial paper. Okay, so commercial paper is a document where it represents value, it represents money. And what you have to do is you have to understand what the purpose of commercial paper is. The purpose of commercial paper is to be able to transfer money without having to carry money around with you. Okay, now we live in a digital age, and we carry a lot of plastic in our pockets that gives us access to our money. Go back 20 or so years, credit cards existed, debit cards were kind of fresh and new, and realistically, the only way to access your funds, assuming, let's say you have a bank account, would be with a check. So basically what you're looking at is we needed a piece of paper that allowed us to access the funds that we had deposited somewhere. We will talk about, we're going to start with that as our basis because that's where this law is, all of the law in this area is based on. And then we will talk later on about the electronic version of this. But commercial paper exists because it gives us the ability to transfer value without having to carry wheelbarrows full of money. Okay, this is a way of representing money with a different document. Okay, that's commercial paper. Now, negotiable instruments are something that is a smaller subset of commercial paper. Negotiable instruments are negotiable commercial paper. And when I say negotiable, that means that we have the ability to negotiate it. Now, when I say negotiate, I'm not talking about, hey, I'll give you $100 for that car. No, I'm asking $500 for this car. Well, I'll give you $250. Maybe I'll sell it to you for $4. Will you take $375? Yeah, that's not what we're talking about here. Yeah, that's negotiation. But in the financial world, negotiation just means we have the ability to take that piece of paper, commercial paper, negotiable instrument. We have the ability to take that piece of paper and transfer it around as if it was that wheelbarrow full of money. Okay, so you give me a negotiable instrument, and I'm going to use checks as the example almost all the time because it's the easiest to see. So you give me a check for $100. So you have a bank account at First National Bank. You give me a check payable to John Gamalchak, $100. You sign it. We'll come back to all the elements in a minute. And now I've got a check for that's worth $100. And if I were to take that piece of paper to your bank, to First National Bank, they would give me the $100. Okay. I don't have to do that. I can negotiate that. I can now use that piece of paper as if it was the $100 without ever having to go back to your bank to actually get the money. So let's say I take that check and I want to buy something from somebody else and the price is $100. I say, hey, I've got this negotiable instrument here from Sally Smith that's worth $100. I'm going to just negotiate this to you. So I could take that check and use that $100 check to pay for something that I want to buy. I am now negotiating that document by sending it to somebody else. Okay, that person is now holding that piece of paper. And oh, by the way, that's the actual title of that person, the holder. Okay, so we're going to have a lot of new terminology, a lot of new vocabulary as we go through this section of the book. And so the person who has had the negotiable instrument negotiated to them becomes the holder. And that's important because later on, you'll find out that a holder may actually end up with more rights than other people in this chain. Okay, we'll come back to that. That person who is the holder, what they did was they sold me $100 worth of goods in exchange for that negotiable instrument. They're now the holder. What do they do with it? Can they take it to First National Bank and demand the $100 in cash? Yes, they can. Can they negotiate it further? Can they take it to another person and buy $100 worth of goods and give that person that negotiable instrument? Yeah, they can. There's really no legal limit to the number of times that a piece of paper can be negotiated. We can send it down the road as many times as we want. We can negotiate it as many times as we want. The problem is that, you know, as you get further and further away from the person that gave you that negotiable instrument, that gave you that check, you start having less and less confidence that it has real value. Okay, so if I know Sally Smith and I know that she's not going to write me a check that's going to be dishonored, it's not going to be an NSF check, I'm pretty comfortable with that $100 check actually representing $100. When I negotiate that to whoever I gave it to, they don't know Sally Smith. Now they know me, and they're counting on me not taking a negotiable instrument that's a bad document. So they have confidence in it. But if we've negotiated this 2, 3, 4 times, it starts getting, I don't know that I really want to consider this to have value anymore. Somebody has to eventually take it to the bank and collect the money. Okay. in the real world, that will happen. I don't think you're going to see it go through more than 2 or 3 hands before somebody's going to go back and ask the bank for the money. All right, so let's look at the definitions of a negotiable instrument. An unconditional promise or order to pay a fixed amount of money if it, 1, is payable to bearer or order, 2, is payable on demand or at a definite time, and 3, does not state any other undertaking or instruction to do any act in addition to the payment of money. A negotiable instrument is a record of a signed promise or order to pay a specified sum of money. Now, I'm going to roll forward just a little bit because, and I do want to go back to promise to pay or order to pay, but the main types of negotiable instruments that exist out there are A, promissory note, B, a certificate of deposit, C, a draft, or D, a check. I think that's as far as we go. Nothing after that, right? Okay, so let's talk about those particular things. A promissory note is a written promise made and signed by the maker to pay a sum certain in money to the holder of the instrument. A promissory note, okay? It's an IOU, okay? So if you want to go to the bank and you want to borrow money, they will require you to sign a promissory note. You will have to actually execute a document which says, I promise to pay this money back to you. I go to First National Bank, I want to borrow $1,000. And they say, sure, we'll lend you that money, but we're going to require you to sign this legal document where you promise to pay this money back. Okay, that makes perfect sense. They want, would you expect anything less from your bank? I wouldn't. Well, that document that you're going to sign is what's called a promissory note. Okay, a promissory note is your first and simplest negotiable instrument. You see, because what we have out there is, and a lot of interesting things go on in the banking industry. Some of you may want to consider going into banking after you graduate. It can be a really great career to go into the banking world, but the problem with the banking world is it doesn't pay real well at the lower positions. You have to actually get some promotions in order to get the big money. So there's a bit of a time frame that you feel kind of abused in the banking industry, but there is a real career out there if you can wait it out. But anyhow, promissory notes are negotiable. A lot of times what happens is banks don't want to service, that's the technical term, they don't want to service the loan. They want to lend the money out. So, for example, in the mortgage side of banking world, the bank charges fees to get into a mortgage situation with you. Oh, you want to borrow money to buy a house? Sure, fill out this application. The application fee is $100. So the bank makes $100 just because you asked to borrow money. Then if they decide that they're going to lend you the money, they'll charge you what a origination fee, which is usually 1% or 2% of the amount of the loan. And then they may even charge you points or prepaid interest. So the bank is out there making money just by creating the loan. Many banks don't want to then own the loan after they make the loan. They want to only make that money that's available to create the loan. Well, now they own the loan. So what do? They sell the loan to another bank that actually wants to just service the loan and collect the interest. Because of course you're going to be paying interest on the loan. The first bank, all they wanted were the processing fees. So how do they get rid of the loan that they've created? Well, it's negotiable. So they negotiate it to the next bank in line. So Bank B, Second National Bank, will buy the mortgage loan from the first bank. The first bank keeps all the processing fees, and the second bank collects all of the interest. Okay. Promissory note, you signed a promissory note to get that mortgage, to get that loan. It's negotiable. Very often they are sold or negotiated to other banks. Okay. The second thing is a certificate of deposit. A certificate of deposit is also called a CD. You may be familiar with them. Your banks do sell CDs. What happens is you give them your money. It's like a savings account, but you're not allowed to take the money out for a period of time. So they'll give you a slightly higher interest rate to do that. A certificate of deposit is a promise to pay issued by a bank. Through a CD, a bank acknowledges the customer's deposit of a sum of money and promises to pay the customer that amount plus the interest when the certificate is surrendered. Okay, so it seems to be like the reverse of a promissory note. Promissory note, the bank is giving you money and you promise to pay them back. A certificate of deposit is you're giving the bank money and they're promising to pay it back. So once again, this is a negotiable instrument. So you deposit the money at a bank, they give you a certificate of deposit, a CD. It's a negotiable instrument. You can then negotiate that to somebody else. Somebody can pay you for that CD because it has value. Okay. Drafts. Drafts are a kind of an unusual animal in this particular area. It's an unconditional order in writing by one person upon another, signed by the person giving it and ordering the person to whom it is directed to pay upon demand or at a definite time a certain sum of money. So a draft is basically like a check, but it's not drawing the money out of your bank account. So let's say that I had money that I had lent to a friend of mine. I lent him $1,000 and he's supposed to pay me back. Maybe I don't even have a promissory note because we're friends and we don't need paperwork, right? I could theoretically issue a draft. I could give you a draft. It would look like a check, but it wouldn't be a check. I'd say, hey, I'm going to give you $1,000. Please pay to the order of, Sam Smith, $1,000. And this is to be paid by Sally Jones, who is holding my money. They're out there. They exist. I'm not going to spend a lot of time with drafts. I will spend a lot of time with check. A check is an order by a depositor on a bank to pay a sum of money to a payee, a bill of exchange drawn on a bank and payable upon demand. Okay, payable upon demand and drawn on a bank. So that is what makes a check unique and the most useful of the documents that we see out here. There are more checks out there than any of these other types of negotiable instruments that we're talking about. Basically, it is an order by the depositor for the bank to pay money to another person. So I have a bank account at First National Bank. I write a check to Sally Smith. Pay to the order of Sally Smith, $100, dated today, January 18th, 2022. And then I sign my name at the bottom of the check. Okay, that's a check. It's payable to Sally Smith. Where's the money supposed to come from? Well, it's drawn on my bank account at First National Bank. Okay, so that's a negotiable instrument. It is a check. It's one of the most common types of negotiable instrument. Now, I want to go back to something that's a little bit prior. I want to talk about the fact that under negotiable instruments, the definition said that it is an unconditional promise or order to pay. You have two things there. You have a promise to pay or you have an order to pay. Okay, go back to the promissory note, or for that matter, the certificate of deposit. That is not an order to pay. That is a promise to pay. I borrow $1,000 from First National Bank. I sign a promissory note. That note will specifically say, I, John Gomolchak, promise to pay $1,000 plus interest to First National Bank. There'll be more details, but that's it. Okay, that is a promise to pay. The other side of this is an order to pay. A draft is an order to pay. A check is an order to pay. Okay, so understand the difference. They both qualify the document as a negotiable instrument, but it could either be a promise to pay or an order to pay. Okay. Let's see, where am I on the, let's see, commercial paper, negotiable instruments, promise to pay, order to pay, promissory notes, certificates of deposits, checks, excuse me, drafts and checks. All right, so now I want to move forward into checks and the different types of checks that we could be talking about. Because once we get into the world of checks, we're getting into the world of banking, and the banks make the rules here. All right, so we've talked about various ways of using a bank to help you process payments or protect yourself in a transaction. If you remember last semester, we talked about letters of credit and things like that. Right now, we're going to talk about how you can use the checking system. More generic term, the payment system of the United States, to control and protect your money as it moves through the payment system. Okay, so we can have things called cashier's checks, teller's checks, traveler's checks, money orders. These are different types of checks that can exist and do exist out in the economy. If I write a check, okay, a personal check, we're just going to call it a personal check at this moment. If I write a check, I have a bank, an account at First National Bank. I write a check for $100 to Sally Smith. I give that check to Sally Smith. It theoretically is worth $100, but it's only worth $100 if I have the $100 in my bank account, correct? If I don't have that $100 in my bank account and Sally Smith takes that check and goes to the bank and asks for the money, they will dishonor the check. They will say, no, the check is not any good. There are not sufficient funds to pay this check, and they will refuse the check, okay? So me giving you a check is my effort or attempt to pay you, but it's not guaranteed payment. It's only going to be honored by the bank. The bank is not going to honor it if I don't have money in my account. The bank is under no obligation to give you money if I don't have it in my account, right? If you want to make sure that a check will cash, there are ways to do it in the payment system. Okay, so we have something called a cashier's check. A cashier's check is something that is created by the bank itself. So, hey, let me pay you for that. I'll give you $100 if you sell that to me. Great, yeah, I'll sell it to you for $100. Here, let me write you a check. No, I won't take your check. Cash, please. Well, I don't like dealing in cash. Well, then we have a problem here because I have no guarantee. I don't know that your check is going to cash. I'm not going to take your check. Well, what can I do to make sure that this transaction happens? Well, I'll take a cashier's check. So in order for me to create a check that will satisfy the seller, that it cannot bounce, that it will never be dishonored, I can do what's called a cashier's check. So what that means is I would then go to the bank and I would ask the bank to create the check itself. So it wouldn't be me writing a check out of my checkbook. I would be going to the bank and I would say, in essence, what the transaction is I would withdraw $100 from my account and then give it right back to the bank, asking them to turn that $100 into a check. So then what would happen is I would receive what's called a cashier's check. It is a check that is drawn by the bank, not against my account, because my account, there's no guarantee there's going to be money there. That cashier's check is drawn on the bank itself. Okay, so that check will cash unless the bank goes bankrupt, goes out of business, right? We have all kinds of ways of making sure that that doesn't happen. So if somebody wants to give you a check and you want to make sure that it will cash, that there'll be no problem with it whatsoever, you ask for a cashier's check. They will then end up getting the bank to write a check against its own funds. Now, the way, as I explained, what happens is the bank would physically take the money out of my account and put it into their general fund, because they're not going to be paying it if I don't have the money. Okay, so that's how a cashier's check works. Now, it's not listed here, but I want to talk about it real quick. There's something called a certified check. A certified check is also a type of check that will not bounce. The check will be cashed by the bank. And what a certified check is I write a personal check out of my checkbook to Sally Smith for $100. And then I take it to the bank and I tell the bank, Sally Smith wants this to be a certified check. Well, the bank will then stamp it on the back, certified by First National Bank. Okay, that means that they guarantee that they will cash it when it comes through the payment system. Why will the bank do that? Well, it's going to be very similar to the cashier's check. They're going to look in my account first before they certify that check. And then what they'll do is they'll take that $100 out of my general fund in my checking account, and they'll put it up into what's called hold. They can put money on hold in my account. So they'll take that $100 and put it on hold, waiting for that check to come back. If other checks come back in and wipe out the remainder of my account, so be it. That certified check will cash because they're holding that $100 separate to make sure that that certified check will get through. You will see certified checks when you're dealing with sophisticated business people. You won't see this in the general public. You'll see cashier's checks or money orders in the general population as, oh, that won't bounce, so I'll take that. A teller's check is interesting because it's actually a check drawn by a bank on an account in a different bank. So you may have First National Bank that has an account at Second National Bank. So a teller's check is going to be First National Bank writing me a check on the account that they have at Second National Bank. Once again, it would be a pretty sophisticated transaction in the banking world, not something that we're going to see on a regular basis out in the public, so to speak. A traveler's check is something that's issued by various companies that guarantee that they will make payments on checks. Basically, instead of carrying cash when you go on vacation or you're traveling, you turn your cash into traveler's checks. That way, if they're ever lost or stolen, the company that issued them will replace them for you. So it's a security thing. Once you countersign the traveler's check, it turns it into cash. It makes it negotiable. A money order is a smaller version of a cashier's check. Banks do money orders. For example, when I used the example earlier that I would go to the bank and ask for a cashier's check of $100, my bank wouldn't give me a cashier's check. They would give me a money order. Same basic thing. It's drawn against the bank, so it's not going to bounce. A cashier's check at my bank, I think, has to be over $10,000 before it would actually be a cashier's check instead of a money order. Now, you can also buy money orders from other businesses. I know you can buy money orders from the post office. I know that I can go to the country fair and I'm near my house and I can buy a money order. All that means is you're relying on somebody else's reputation to pay that check rather than your own. Okay. Any questions so far on this section of negotiable instruments? Everybody sleeping so far? Okay, that's fine. All right, parties to checks. We have maker, drawer, drawee, payee, acceptor, and secondary obligor. So let me get back to my material here. All right, maker. Maker is the party who writes or creates a promissory note. All right, so not a check. So a maker is whoever creates the document that promises to pay. Got it? Not an order to pay. It's a promise to pay. The promissory note, the certificate of deposit are promises to pay. Whoever creates the document is the maker. The drawer is the party who writes or creates a draft or a check. So if you have a promise to pay, it's a maker. If it's an order to pay, which would be a draft or a check, that would be drawer. Okay, so if I write a check to you for $100, I am the drawer of that check. The drawee is the party to whom the draft is addressed and who is ordered to pay the money and who is ordered to pay the amount of money specified in the draft. So the drawee is where the money comes from. If it was a draft, remember that means that somebody else other than the bank was holding my money. That person would be the drawee. The bank would also be the drawee on a check. Payee. The payee is the party to whom the payment is to be made. So in this case, it doesn't matter if it's a promise to pay or if it's an order to pay. The payee is the person who will end up with the cash eventually in the end. The acceptor, when the drawee of a draft is indicated in writing or record a willingness to pay the amount specified, that's an acceptor. That just is an interim step here. Whoever the drawee is, they've said, yes, we understand we have an obligation. So once again, not something you see a ton of out in the real world. Secondary obligor, when a party who was not originally named in an instrument allows her name to be added to it for the benefit of another party to add strength to the collectability of the instrument. I give you a check for $100. I buy something from you for $100. I give you a check. It's right before spring break. You don't have a chance to go to the bank that you use in Greenville. So you go home to wherever home is for spring break and you carry that check from me with you. So you want that $100. So you go to the bank and you say, hey, I want to cash this check that Gamalchak gave me. Well, let's say that you live, on the West Coast somewhere, and people in San Diego have no clue who I am, and they're not real interested in giving you cash because they're not sure that I'm going to make the check right. So they'll refuse to cash the check, not because they know that I don't have the money, but because they're concerned and worried. They don't know if they'll be able to collect it. So you go home and you tell your mother, geez, the bank wouldn't cash the check for me because they say they don't know Gamalchak. So your mother says, you know what? Hey, I'll go down to the bank with you. I've got an account there. So your mother goes down to the bank and says, hey, what's the problem? Why won't you cash this check my son brought into you? Well, we don't know who Gamalchak is. And your mother says, well, if I sign the check in addition to my son, will you cash the check? Yes, we will, because we know you, Mom. So that's a secondary obligor. Later on, when we talk about liabilities on negotiable instruments, you'll see that these people who were signing the back of the check are making promises to whether or not that check can be cashed. So when your mother signs the check, she's basically guaranteeing that I'm going to make that payment. If the check ends up NSF and it is refused by my bank, your bank is going to go after your mother. All right, negotiability, the quality of an instrument that affords special rights and standing. Negotiable instrument, contract note or draft that does not meet negotiability requirement, or non-negotiable instrument does not meet negotiability requirements. All right, the definition of negotiability. Let me just double check something here. Yep, we've gone through all that. Requirements of negotiability: record, authentication, promise or order to pay, unconditional promise, payment in money, sum certain, time of payment, and words of negotiability. Those are the things you need in order for something to be a negotiable instrument. Now, I gave you the definition of a non-negotiable instrument. It means that that instrument failed one of those tests of those elements, and it made it non-negotiable, which makes it a contract only, not a negotiable instrument. You want to be able to have something become a negotiable instrument because Article 3 of the UCC applies to negotiable instruments, and it gives superior rights to some people in the collection system. If it's merely a contract, you remember you're under Article 2 or even common law. All right. The quality of negotiable instruments creates opportunities for transfers and financings that streamline payments in commerce. Transfers can be made with assurance of payment without the need for investigation of the underlying contract. Moving forward. All right, so a record. Now, if we were talking about the original version of Article 3, it would say a writing. But now, since we live in a digital world, it's a record. A record just means that it is something that can be reproduced. It can be something in digital form. It can be an email. It could be, any of those electronic versions of documents. Okay, so a record. If you want to use the old terminology, a writing, you have to have something that you can look at. It has to exist in visual form. It doesn't necessarily have to be physical, but you have to be able to see it. Okay. So if it's a document that's being electronically stored on the computer, that is good enough to make it a record. Authenticated or signed by the maker or drawer. If I write a check, I have to sign the bottom of it. If I promise to pay, I have to sign it, saying that I'm promising to pay. Okay, so it has to be signed. If you don't sign it, it doesn't exist. Absence or representative, capacity or identification of principal. Sometimes you can have agents that sign things for you. So if I'm a corporation, one of my employees, let's say the treasurer or the controller, somebody like that is going to be signing the checks, that type of thing. So I can have people in a representative capacity sign documents for me. That's fine. But if you're ever signing in a representative capacity, you're signing the check for somebody else. You're signing the promissory note for somebody else. Make sure that your signature includes the fact that you are signing in a representative capacity. This is a $100,000 promissory note that I am signing on behalf of Acme Incorporated, a corporation that I am an officer of. If I'm the president and I'm signing as the president of Acme Incorporated, at the bottom of that promissory note, I should sign Acme Incorporated by John Gomulchek, president. That tells everybody, tells the world, I am not signing in my individual capacity. I am signing only as a representative in my representative capacity as president of the corporation. Be careful. When you are signing things on behalf of somebody else, you are power of attorney for somebody, then make sure you make it clear you are signing as the representative, power of attorney, or agent of that person. If you are an officer of a corporation or of a business, make sure that you put in there that you are signing on behalf of that entity and what your position is. Promise or order to pay, we talked about that. So a negotiable instrument has to have a promise or an order to pay. Unconditional order to pay, it can't be conditional. You have to say, I am going to pay you this $100, or I'm going to pay you this $1,000. Or, it can't be conditional. I'll pay you this $1,000 if the Steelers win on Sunday. Well, that's conditional. It makes this a not negotiable instrument. Okay, to be negotiable, the payment has to be unconditional. Now, that doesn't mean that there can't be additional terms. So for example, on a promissory note, I'm going to promise to pay $1,000, but I'm also going to say in there that I'm going to promise to pay the interest, right? Because a loan is not usually done on an interest-free basis. So I'll pay $1,000, 90 days from now, I'll pay $1,000 plus interest calculated at 10% per annum. So whatever the interest factor would be, I would pay $1,000 plus whatever that number is. We could calculate that so we could know what the number is. It's an absolute number and then there is no condition. I think I got ahead of myself here. Payment in money, it has to be paid in money. I can't pay you in goods. I can't write you a check for 1,000 widgets. No, I can give you a check for $10,000 or $1,000, but it has to be money. Now, does it have to be US dollars? No, you can choose whatever currency you want to use, but it has to be money. All right, sum certain. I sort of got a little ahead of myself on the interest thing. A sum certain. It has to be a sum certain. I will pay you. I promise to pay you in 90 days from now $1,000. That's a sum certain. In addition to the $1,000, I will pay you interest at calculated a rate of 10% per annum. So whatever that's going to be, 3/12 of 10% of $1,000. That would be the interest. We can calculate it. That doesn't change it. That is not a sum certain. It is still a sum certain. We do understand that interest does exist in our economy. What if the interest rate is something that is floating, that it can be reset on a monthly basis to the prime rate as set by First National Bank? Well, it's just going to be harder to calculate because we don't know what the interest factor is going to be until the bank sets their prime rate. Yeah, that's true. But it's still able to be calculated, so that doesn't change anything. It's still a sum certain. We're still good with that. And that's not a problem. Time of payment. So we need to know when the time of payment is going to be. It has to be at a specific time in the future, or it can be on demand. Okay. A negotiable instrument must be payable on demand or at a definite time. An instrument payable only upon the happening of a particular event is not negotiable. Once again, that makes it conditional. Plus, it makes it so we don't have a specific definite time of payment. Demand, that means it's payable immediately. If I write you a check, that's a negotiable instrument. I'm going to just give you that as a given. A check is always going to be a negotiable instrument. When is it payable? Well, when I give you the check, do you have the ability to run to the bank, right at that moment and cash it? Sure you do. Do you have the ability to put it in your wallet and I'll be going to the bank on Friday, I'll cash it on Friday? Yes, you do. But it's payable upon demand whenever you choose. It's payable immediately. But it doesn't have to be negotiated immediately. It just has to be negotiated whenever you want. Okay, that's payable on demand, on site, on presentation. Okay, a definite time is a fixed time after site or acceptance that that is easily ascertainable from the document. So it can be 30 days from now. It can be a very specific date, February 28th, 2022. All right. If we don't have a date on the instrument, an instrument that is not dated is deemed dated on the day that it was issued to the payee. Any holder may add the correct date to the instrument. So even if we forget to put the date in, it doesn't mean there's not a definite time. That just means that we're going to rely on the law to tell us when that time is. And so that's going to be the law putting it in, which is, okay, I gave it to you today, January 18th. So the date of the instrument is today. All right, double checking here. Words of negotiability. We haven't talked about this yet. In order to make it a negotiable instrument, it has to have words of negotiability. If I were to write a document that said, pay to Sally Smith $100, you'd say, well, it sounds like a check. It does sound like a check. It's an order to pay, not a problem. Unfortunately, it doesn't have words of negotiability. That means according to the term, the words that are on that document, the only person who was capable of or allowed to negotiate that document is Sally Smith. She's not allowed to negotiate it to somebody else. Sally Smith would be required to take that back to my bank and demand the money. Okay. There are no words of negotiability. So words of negotiability are pay to the order of John Jones, or pay to John Jones or order, or pay to bearer, or pay to John Jones or bearer. The phrase pay to the order of John Jones or John Jones order show that the person executing the instrument had no intention of restricting the payment to that John Jones specifically. Okay. Pay to the order of somebody, or pay to John Jones or his order means we don't care who ends up with this document. We're giving it to John Jones. That's who we're paying, but we don't care what he does with it. He can negotiate it to somebody else, or he can take it back to our bank. We don't care, but we have put in the additional words of negotiability. Now, the other thing is we can say pay to the bearer. Okay. That means whoever has possession of the document has the ability to negotiate it. Yeah, that's true. That's what we can do. Do we want to do that? It's up to you. I don't care. Most people prefer to do pay to the order of and put a name in there because it adds a level of security to the document. Because see, if I just write a check, you know, Sally Smith needs $100 from me and I write a check for $100 and I just write pay to the order of bearer $100 and give it to Sally Smith. If Sally loses that check and somebody picks it up off the sidewalk, can they cash it? Yes, they can, because it's whoever is in possession of the document is allowed to negotiate it. So bearer instruments, they exist. They are not a real problem, but understand they take a level of security out of this payment that we're, this payment streak or string that we're trying to do here. Okay. So bearer, payable to cash, in the old days, we would write checks to cash. That just means whoever is holding it, that made it a bearer instrument. Okay. So understand, and I'm going to guarantee you that this will be on the test at some point when we have a test. Know the difference between order paper and bearer paper. Order paper, an instrument payable to the order of a party. Bearer paper, an instrument with no payee, payable to cash or payable to bearer, the person in possession. Okay. Bearer paper, an instrument is payable to bearer or bearer paper when it is payable to one bearer or the order of bearer, to a specified person or bearer, or to cash, the order of cash, or any other designation does not purport to identify a person, or when the last or only endorsement is a blank endorsement, an endorsement that does not name the person to who the instrument is negotiated, an instrument that does not identify any payee is payable to bearer. I write a check to Sally Smith, pay to the order of Sally Smith. That is order paper. It's got the security on it. Okay. Sally Smith negotiates it to Tom Jones. So on the back of the check, she writes, she signs her name, Sally Smith. She has converted the order paper into bearer paper. By signing the back of it, she complied with the requirements of order paper, but didn't do anything to maintain it as order paper. So just it's called a blank endorsement, just signing your name. It turns order paper into bearer paper. So we'll see when we get to endorsements in, I think, the next chapter, that you can put additional words in your endorsement when you sign the back of the check. Okay. All right. The last thing on the outline is the statute of limitations. If you look in your book, you will see a chart that has various languages: pay to the order of ABC, pay to order of bearer, pay to blah, blah, blah. And it tells you whether it's order or bearer paper. Real quick, before we get to statute of limitations, because I have 2 minutes. We do have rules of construction here, and they are very similar to what you saw when we had rules of construction for regular contracts. Words control figures where conflict exists. Handwriting supersedes conflicting typewritten, which supersedes printed forms. And if there's a failure to provide a payment of interest, if there's a provision for the payment of interest, but no rate is mentioned, the judgment rate at the place of payment applies. So there are some rules out there for that. Statute of limitations for negotiable instruments. Article 3 establishes a 3-year statute of limitations for most actions on a negotiable instrument. There's a 6-year limitation for certificate of deposits and accepted drafts. Not super important. I don't know that you have to worry about that for the exam, but something to know. All right, anybody have any questions? Okay, so that's it for today. That's the first chapter for negotiable instruments. We will be meeting again on Thursday at 8 o'clock. It will be on Zoom. Again, I can guarantee you that I will still be on Zoom. Other people may be back in the classroom, but our class will still be on Zoom as of Thursday. The invitation, the Zoom invitation that you received, I set it up as a recurring, so keep that same invitation to attend Thursday's 8 o'clock class. Glad to see everybody back. I'm hoping to be back in the classroom sooner rather than later. Sooner means that my son has gotten better and I'm able to come back home. But until certain circumstances changes, I will be remote. And like I said, if you need to reach me, yeah, probably email will be the easiest. Obviously, you can talk to me when we're in classroom mode here. So if there's no questions, then that's it for today. We'll see you on Thursday.
Have a good day.
Thanks.
Have a good day. Thank you.
Thank you, Grace.